Hi, I'm Graham Walker from roadtrafficlaw.com solicitors. Many of the clients who come to us have never been in trouble with the police before, so we decided to set out some videos to explain some of the procedures that you might be involved in. The first of these videos is today's, and we're going to be talking about drink driving and drink driving procedure. The first thing that will happen in relation to a drink driving case is that a police car will normally pull you over, or you'll be stopped at a roadside police check. There's a common misconception that the police can't stop you unless they have a very good reason. And you may have heard something in the press from the Scottish Justice Minister, Mr McCaskill, talking about the possibility of opening matters up so that police do have the opportunity to stop vehicles without any just cause. That's a wee bit confusing because police officers stop cars randomly pretty much all the time. They will always have a reason, they'll always come up with some excuse, but believe you me, if a police officer wants to stop your car, he'll do so. We had the situation very recently where a client contacted us to say that the police gave the reason as being he was driving on a cold night with his window open, and since his window was open, they suspected that he was drink driving. And that was upheld by a sheriff as being a reasonable excuse for the police officers to suspect something and pull him over. So don't think that there's some kind of mysterious governing body looking out for you, the motorist, and making sure that no one is allowed to stop you. If police officers want to stop you, they can, and they will. The first thing that will happen is that they use a handheld intoximeter that you've probably seen on TV shows and the like, and they'll ask you to blow into that, see whether it gives a positive reading or not. That is quite a difficult procedure. It's not just a short breath that's required. You have to provide a long and consistent breath into that machine. And if you do have any difficulties like asthma or any other medical difficulties, it would be wise for you to say to the police officers right at that stage what your difficulty is, and to certainly try to give a test to the best of your ability. Bear in mind that the handheld device is not going to be used in evidence against you. This is just a preliminary measure that the police are doing to see if they've got, if their suspicions are upheld, and you should be taken to a police office for a further procedure. Now, if that machine reveals a positive test, you're going to be taken to the nearest police station that has an intoximeter device, or an ECIR device, or chemic breath analysis device. When you go there, you'll see the duty officer, and the duty officer will explain that a procedure is going to be followed, and you'll be taken into an ECIR room where you'll be given this breath sample into the machine. Again, not something that's just a 1 second breath into a machine. The whole procedure will be read over to you normally, unless the police officers are particularly experienced, and they'll just explain to you what the procedure is for breathing into that machine. Now, again, unless you have a very good reason, you shouldn't fail to provide a breath test. Don't think for a minute that a good reason is that you haven't had the chance to talk to a lawyer and you don't know what your rights are. Many people are under the misguided belief that if they haven't had a chance to speak to a solicitor, or they haven't had their phone call, as they put it, then they're not going to go along with any police procedure which might cause them some difficulty, or that they feel is in some way fundamentally flawed or unfair. The answer at this stage is do your best to provide the breath test, otherwise you will be charged with a separate offence, and that's an offence of failing to provide the breath test that's been required, and equally you'd be looking at a disqualification there. So make your legal arguments later, contact your solicitor later if necessary, but at the moment cooperate fully with the police procedures. So you'll be asked to provide a breath test into this machine that's sitting on the table. Once that's done, it will print off something that looks like a till receipt, and on that till receipt there'll be a few different readings. First reading will be something to show that the machine has calibrated, and it means that it's working that day and it's working at the appropriate levels for their analysis. The next reading will be your first breath test, and then there's another reading which is the second analysis of your breath. The following reading and last reading is the final calibration of the machine. So first reading should be around about 34, 35. Next reading should be whatever the alcohol level is in your breath. Similarly with the next one, and the final one, again, calibration reading 34, 35, round about there. If there's much variance in your own readings, or if there is much variance in the calibration readings, then you've got a real cause for concern, and you should contact a solicitor as soon as possible and hold on to that till receipt. The receipt or the document will have been provided to you by the police, and they'll have asked you to sign the bottom of it, and the police officers will have signed that till receipt also. I keep calling it a till receipt, the Camic Breath printout, or ECIR printout. You'll have that signed and provided to you. Keep it. It's an important piece of evidence, and you should provide it to your solicitor as soon as you go and see a solicitor. And I would suggest that that should be your next stop. The next procedure is that if you have provided a positive test, then clearly the police officers aren't going to just set you back into your car, hand you your car keys and send you home. They're going to wait for you to sober up, and what they'll do is place you in a police cell, which is a pretty awful experience for all concerned. They don't allow you to see a solicitor there and then. They will allow you to have a phone call made, and the phone call can be to a solicitor, a family member, or whoever you choose, just to inform them that you're in custody. Many people at this stage do take the opportunity to have their solicitor informed, but equally it might just be a question of letting your wife or your husband know where you are and that you're going to be in custody for a few hours at least. Normally you're detained until the next day, at least until the alcohol has gone through your system, and then you will sometimes have another breath test prior to being released. It surprises me how often the police release people without a subsequent test and hand them the car keys and let them drive off, but generally now the procedure tends to be that another test occurs prior to you being released. Then you're given a pink form by the police officers, and that's called a bail undertaking form. The pink form is a one-page sheet detailing what court you have to attend, when you have to attend it, and the terms of your bail. You're basically being given police bail. Now that means that if you fail to attend court on the date given, you're committing another crime. So that's again an important document. It provides you with detail that you require, and again you should take that to a solicitor as soon as possible. So the next step will be preparing yourself for your court appearance. Your court appearance will probably be within 10 days of you being processed through the police office. So you should use that time by locating, I would suggest, a specialist solicitor like ourselves, somebody who deals with road traffic law all the time, and go and consult with them as soon as you can. It's important to give them as much information as you can, particularly if they want to try to secure some evidence on your behalf. There's a possibility that there may have been some difficulties when you gave the breath analysis, and it's important for your solicitor to try to secure evidence at the earliest possible opportunity. And that can mean a letter to the police asking them to make sure that a log is available or part of the instrument is available to be checked. It can be many things, but basically the important thing for you is to make sure that you tell a solicitor what your position is, what you understood the reading to be, and any concerns that you might have about that entire procedure. On the date of your bail undertaking, you will attend the given court, and you are generally met outside the court a few minutes prior to it starting by a police officer who will hand you a charge sheet or copy complaint. That sets out exactly what it is you're charged with and what you're going to be asked to answer when you go into the dock of the court. There aren't many opportunities at this stage to see a solicitor, but there will be a duty solicitor present. He's really there for people who are unrepresented, and usually for people who require legal aid. It's fair to say that it would be very wise if you were to obtain a solicitor prior to going to court. To give you an idea of the level of business in Glasgow, a duty solicitor can often deal with 100 or 150 people within the space of an hour. You don't need to be a genius to work out the arithmetic on that. So there's not a great deal of time with each person prior to them attending court and tendering a guilty plea or a not guilty plea. So the best advice is see a solicitor before you attend court. When your case does call in court, you'll go forward into the dock and be asked to plead either guilty or not guilty. The clerk identifies you, just asks you to confirm your name and your address, and usually your solicitor will stand up at this stage and say guilty or not guilty. If he says guilty, you can expect to be disqualified. If you haven't been convicted of a drink driving offence within 10 years, then the minimum disqualification is going to be 12 months. There are ways to reduce that, and the main way to reduce that period is through your ability to attend something called the Drink Drive Rehabilitation Scheme. Now, this is a scheme that really is at the discretion of sheriffs or magistrates whether they allow you to be placed onto the scheme, and usually your solicitor would request that you be allowed that opportunity and would explain to the court that you understand what the Drink Drive Rehabilitation Scheme is and that you are willing to pay for it. It's well worthwhile therefore contacting a specialist who can advise you before you go to court exactly what the scheme is, how much it costs, how it's put in place, and the impact that it can have upon any sentence when you come to court. Assuming you plead not guilty, the next step in procedure is the clerk will read out 2 dates. One's called an intermediate diet and the other is a trial diet. You're going to require to attend court on at least 2 occasions in relation to this court. The intermediate diet is a formal court appearance, and at that all that happens is the court wants to assess whether your case is prepared and ready for trial, or whether you require to adjourn the case or the Crown require to adjourn the case for any reason. The intermediate diet itself is relatively straightforward and quick. The difficulty with it is that in busy courts it can take several hours for you to be processed through the whole court regime. And again, I would suggest that if you have an experienced solicitor available, he'll try and have your case called early and get you in and out of the whole court process in a relatively quick and uneventful fashion. The main event is going to be the trial. At the trial diet, if your defence is entirely a technical defence, it's unlikely that you will require to give evidence. If, on the other hand, there is something about the credibility of the officers, or you're saying that there is something in the procedure that you don't accept happened, you may require to give evidence yourself. The trial diet is normally a few weeks after the intermediate diet, and it would be wise for you to have visited your solicitor shortly after the intermediate diet to discuss all aspects of your case, make sure that your case is fully prepared and that your counsel completely understand exactly what your position is in the case. Don't wait until the day before your trial or a couple days before your trial. Make sure you've done it a few weeks before the trial, and certainly at or around the time of the intermediate diet you should be discussing with your solicitor the ins and outs of your defence and exactly what's going to happen procedurally when you attend at the court. The bottom line of all of the advice in relation to drink drive procedure is see a solicitor early. I would suggest contact a specialist. I'm prejudiced, but I would suggest that you contact us. However, there are other specialists in the area. You might want to go onto the internet and do some research and find out who has the experience, the knowledge and the ability to look after you confidently and properly when your case comes to court. I would suggest that you contact us. You can call us on 0800 612 9597 or go online and give us some details about your case, and we'll come back to you with some answers that are specific to your case within the next 6 hours.